Honorable George Kangwachsanga, a Member of Parliament for LUKASHYA constituency, but also a legal practitioner belonging to the Law Association of Zambia. Thank you.
Maybe if you could clarify, are you submitting as Lars or you are submitting as an individual, because you have added...
Chair, I'm actually submitting as an individual.
Thank you very much. And I'm Honorable Andrew Tengwa, Member of Parliament for Kabwata. I'm the chairperson for today. Witness, we want to confer you with our captive immunity, so that whatsoever you shall say here, if it is true, the law will not work against you. But if you willfully decide to mislead us, the same captive will actually work against you. We've read through your submission, and all the honorable members have actually read through. So we would request you if you could stick to your critical points. You have 10 minutes to submit.
I'm grateful, Chair. Again, thank you for the opportunity to allow me to come and submit before your respectable committee. Chair, like you pointed out, I have done a written position. Unfortunately, I didn't know the bill number that we're dealing with, so in the subject it refers to bill number blah 2025. But the crux of my position, Chair, is that we are about to introduce legislation that can, for lack of a better term, be described as regressive and not progressive. And I have tried to argue by first justifying the historical reason why there's a straight-jacketed way in which legal systems allow challenges to be made to ownership of land. For emphasis of the point, Chair, I have tried to argue that you are trying, or this legislation is trying to undo a rule for land law and title holding that today is 810 years old. Because in 2015, rather in 1215, the year 1215, the UK almost exploded into civil strife. Because at that time the UK was a serfdom. There was the king, there were the barons, and there were the subjects. Unfortunately, because of attempts to scuttle land title and land tenures, the subjects decided to wage a revolt against the king. And any scholar of land law will tell you that in that year, in 1215, the king decided to enact what is known as a Magna Carta. The Magna Carta is basically a legal instrument that is classified as a first constitution ever written. And in regard to holding land titles, the king and the barons agreed that they will respect the right of citizens to own land and own it via what is called a title deed, which is why when we own land now, a certificate of title is called a title deed. I've argued, Chair, that this is the entrenching rule when it comes to dealing with title deed or titling of lands elsewhere within the Commonwealth, of which Zambia is but part. I have then moved on to discuss the current legal framework that we have insofar as holding title deeds and how the title deeds can be transferred, and the challenges that can be made to whether a title is being held legitimately or lawfully, or there's something untoward with how it is held. And I've argued, Chair, on my point too, that the only power the statute currently gives to registrars is for them to maintain the register, as well as to undertake corrections of omissions and entries that are made in the register itself. Never to cancel title deeds, never to refuse to give title deeds. So this amendment is proposing to introduce a power on the registrar whose responsibility is to maintain the registry at the Lands and Deeds Registry, to undertake what is called a quasi-judicial function, to be able to exercise as an individual the power to cancel a certificate of title or to refuse to issue a certificate of title if he thinks or she thinks the person who's concerned does not merit being given a certificate of title. This is the input of the amendment that is being proposed. I have then argued, Chair, that this is a departure from what was intended by the Magna Carta and what was then undertaken in terms of reforms. For brevity of time, I wasn't able to refer to what is known in Zambia as a watershed speech, which is a speech that Dr. Kaunda gave in 1973 when we changed the land tenure with a view to protecting the owners of land. At that time, it was felt that many people that held land were actually not in the country, and the intention was to allow for Zambians to own land. But that land being held by people that were not in the country, the government had to take a wide-ranging consultation among its stakeholders on how Zambians wanted land to be held. And that resulted, Chair, in the watershed speech, which everybody who's done history will remember, that 1973 or 75, there was the material reforms where Kaunda gave a watershed speech, and this is where the current titling system partly comes from. There are provisions in the current Lands and Deeds Register, section 33 and 34, that clearly provides on how you can alienate land or a certificate of title from an individual. What is cardinal in those provisions is that it is only the High Court of Judicature that is given the jurisdictional mandate to cancel certificate of title, and on grounds that have been proved. I'm not going to go through each item, but I've itemized for the committee the provisions of section 33 and section 34 of the Lands and Deeds Registry Act. Now, this is important, Chair, because what is intended by this section that is being provided, that is being proposed, section 57A, is actually a duplication of these two sections, but also a suggestion that we can either transfer the power to cancel titles from the High Court of Judicature to a registrar at the Ministry of Lands, or if not to transfer, we are trying to duplicate the jurisdiction. We are trying to give to the registrar the powers that are given to the High Court by the law. And I've emphasized that this is not progressive, it is regressive, because the High Court is set up by the Constitution, and the High Court is vested with what is called original and unlimited jurisdiction to deal with disputes amongst them land matters. And if we are going to confer powers on the registrar, to do what the High Court has been given power under the Constitution to do, we will actually be acting unconstitutionally. Chair, I've also tried to, when I tried to examine whether this is a progressive step we are taking as a nation, I thought I should be more objective in trying to help the committee. So I undertook a very casual but quite informed, comparative analysis with other countries within the Commonwealth, because like I said at the beginning, the Commonwealth draws most of its laws from the UK using what was contained in the Magna Carta. And what I established, Chair, I have actually recorded in item number 3 of my write-up, where it is looking very consistent that throughout the Commonwealth, there is no country, at least these ones that I've looked at, which confers powers on the registrar to cancel certificates of title. And the reason is simple. It is because the power to cancel certificate of title is supposed to be an aspect of what is called equitable jurisdiction of the Superior Court of Judicature, of which the High Court is the lowest, because it's a High Court, Court of Appeal, and then the Supreme Court. But that power, which is called the equitable jurisdiction, allows the court not only to examine whether they should cancel a certificate of title or not, but in most instances where certificate of title are supposed to be considered for cancellation, you also look at the what are called unexhausted improvements. People build on these pieces of land. If you cancel a title, you must consider what are you going to do with what has been constructed on the piece of land. A registrar would never exercise those kinds of powers. So in the end, Chair, I've got a graph that I've put there which shows clearly which provisions we are dealing with in drawing up those comparative analyses. But the strong argument I've made before the committee, Chair, is that it is not progressive for this country to suggest that we can make an incursion into the Lands and Deeds Registry Act to give the registrar the kinds of powers we're about to confer on the registrar. One point that should also be made clear, again because of lack of time I didn't consider it, is that when you are considering the amendment to the law, you should always look at the implications of that law on any other pieces of legislation. We've got other pieces of legislation in this country, like the Agriculture Credit Act, that allows people to use land or to borrow money as agriculturists. There is also the Lands Act that is run alongside in administering registration of titles at the Ministry of Lands. Those kind of laws might be implicated. I wouldn't have enough time to extrapolate that, but those would have to be looked at. The point, Chair, to make is that that when you are going to reform a piece of land that deals with something as important as land tenures and certificates of title, you can't just pick one piecemeal provision in the statute and propose to amend it without looking at how it is going to affect the other areas that administer the same kind of subject matter that has been considered. Those are the views, Chair, that I thought I should come and share with you, and I hope I've used my 10 minutes correctly. I'm grateful.
Thank you very much for sticking actually to time. Honorable members, I think we are now free to ask points of clarification if we have. Honorable member, witness, sorry. Let me take you back to your own submission on page number 2, where you see where you have indicated, I think number 2 also, the Zambian legal framework and judicial system, judicial authority. Here you pointed out in section 11, Lands and Deeds Registry Act, such powers are restricted to correction of errors, omission, or entries made or produced by fraud or mistake. I just wanted to find out what is wrong with this. Now, if we want to confer the registrar, the chief registrar, with powers to cancel the title deed. Then number 2, I just wanted to find out what is your opinion in a person who goes and applies for a piece of land on a road reserve. Okay, he applies for a piece of land on a road reserve, and the title is given fraudulently or erroneously. The community raises and decides to go to court. So what is right, to cancel the title deed, or you follow the process of going to court? The other question I have is, because I heard you kept on saying the chief registrar is going to usurp the powers of the High Court if the chief registrar is given the powers to cancel the title. I have not heard you talk about the appeals hierarchy, where one will appeal to the minister, then that person, if it fails, they can appeal to the lands tribunal. If that fails, you can appeal to the High Court. The High Court is still there. The powers are still vested in the High Court. They will make a final decision at the end of the day. So I wanted you also to comment on that. We can also add one from Honorable from Honorable Simbao.
Thank you, Chair. It's just to amplify your question, Chair, but maybe I'll ask it in slightly different way. Honorable, I hear your submission very well. I want you to comment on my poor people in Rwansha. I've had situations in Rwansha where someone, you find that they get land away from him, and especially the foreigners, they are given a piece of land which belonged to the Zambians, and they had papers. There are incidences where they've got also those papers. But to resolve this issue, they've been referred to go to the courts. And my people in Rwansha, a number of them cannot afford the court fees. As a result, they've ended up giving up. As Chair has pointed out, since this amendment is not changing anything at all, the people will still be free to go to the courts of law, except that we want to bring in this aspect where a poor person from Rwansha can go to the registrar and doesn't pay anything but have the case resolved. If it doesn't work, then they proceed and go to the courts of law. Thank you, Chair.
You can answer those 4 questions.
Grateful, Chair, and thank you very much for the questions. Section 11, Chair, I'd actually said it when I was making my submission, that it does confer certain powers on the registrar, but those powers are just restricted to the corrections to be made on the entries in the register. The register and the certificate of title are 2 different things. The register is a register maintained by the registrar into which particulars of the transactions that take place on that piece of land are registered. And if peradventure it is found that there was an error or some fraud was committed in making an entry onto that register, currently the registrar has got the power to cancel those entries, to make corrections. The registration, you may also need to draw analogies, Mr. Chair and honorable members. The registry at the Ministry of Lands, the registry at PACRA, Registrar of Societies. The responsibility of registrar is literally to maintain what are called registered particulars. If we do not engage ourselves in fraudulent transactions, the scenario that the chair referred to, the scenario of somebody constructing, or taking a title on a road reserve, would not arise. Because all these pieces of land, especially in urban areas, they are on survey diagrams. Or if there are no survey diagrams, the process of acquiring a title to land includes surveying. So if people are conducting themselves properly, you would never conceive of a situation where somebody can be given a certificate of title on a road reserve. I know in practice it happens, but I want to speak about an ideal scenario. The registrar is a person who employs a number of people who undertake work that is condition precedent before issuing a certificate of title. So being the person that has those kinds of responsibilities, if I apply for a piece of land, I should be minded to expect that the officers of the Ministry of Lands are going to carry out a survey, with my involvement, of course. And if it is on the road reserve, they'll tell me, sorry, Mr. Changa, we can't give you this piece of land, it's a road reserve. But we have a scenario where, sometimes because of corruption, these things, the password is called an Ausonian eye. But our argument, Chair, is that you can't still use the registrar because he will be complacent, or complicit rather, in the commission of that crime of creating a title deed on a road reserve, because it is his or her officers who had gone down to conduct those kinds of investigations. And if then it is discovered that something was wrong, you need to take it before an independent arbiter who should be able to come and deal with that matter. That's why in cases that you take to court, you cite the registrar as one of the defendants or respondents, as the case may be, because they will need to come and account for themselves. How did it happen that when they were sitting in office, somebody was able to create a title deed on a road reserve? So all those are considerations, but I also raise the issue of compensation. It is possible that I can be crooked and I can get a title deed on a road reserve, but in my crookedness, I would sell the property innocently to you, Chair, and you become the third-party owner of that property. Should we come and punish you in the registrar's office when they discover that actually the property you bought was on a road reserve? No, because the court will exercise the powers which are called equitable jurisdiction to allow that, yes, we can cancel this certificate of title, but either we can allocate a replacement or we can compensate the innocent victim of Mr. Chisanga's fraud. But the idea of thinking that the registrar should be one to make those decisions to cancel will even open us up to cases of corruption. I practice in the conveyancing section myself, and I can tell you that in more than 70% of cases, there's complicity either in the office of a registrar or senior officers if any fraud is committed within the registry on issuance or conveyance of certificates of title. But if things are conducted in strict accordance with the law, I don't conceive of a scenario where you can actually be given a certificate of title on a road reserve. The issue of appeals, the hierarchy that is proposed, it even creates more problems for myself. I had said earlier that in 1975, when Dr. Kaunda made a watershed speech, the intention was to depoliticize the issues to do with land allocation. And that's why when the law granted power in the president, vested power to own land in the president for and on behalf of the citizens, the president was then mandated to appoint a commissioner of lands. And the commissioner of lands is one who exercises powers for and on behalf of the president. That was intended to ensure that we don't politicize land allocation in the country. There has always been a minister of lands in the ministry, but is not anywhere in the appeal processes. The idea is to make sure that land administration has nothing to do with political patronage, and to try and create this hierarchy that I'm seeing in the proposed amendment is to move away from the ethos of what was contained in the watershed speech and even what has happened since 1975 up to now. If we to allow that the minister should be part of the appeal process that we're going to include in the legislation, I would shudder to argue that then we have to do adequate consultation. Whose views are these that the minister must be included in the appeal process before it goes to court? But even then, aren't we going to be elongating the process? Chair, I think you agree with me that land disputes take long to resolve. And if you take it to court, the minimum I found myself trying to resolve a land dispute is 3 years before a court of law. The maximum, I've got a case that has lasted 14 years in the court of law. Now, if you're going to allow a scenario where you start with the registrar, it goes to the minister, and it ends up at the High Court or elsewhere, it becomes a problem. There was a recent innovation that was done by this country. We introduced a lands tribunal. And I think that partly answers what Honorable Simbao had raised. We brought in a lands tribunal first to expedite land resolutions, but also to allow that even those who can't afford to go to the High Court can come to the lands tribunal. The lands tribunal is conferred with almost the same powers that the High Court has. But you see, it is a structure outside the Ministry of Lands to show that there's some semblance of objectivity and independence in how we resolve land disputes. And very interestingly, the lands tribunal's decision are now appealed to the Court of Appeal, because the High Court is always almost placed at the same level as the lands tribunal. This is to underscore the fact that we have to have an independent and objective system of resolving land dispute without involving the very office that is responsible for land administration in the country, that's the Office of Chief Registrar. I don't know whether I've answered even Honorable Simbao's answer adequately.
Yes.
Thank you, Chair.
Thank you very much, Witness. Your concluding remarks.
Thank you, Chair. My concluding remarks are basically that this is not a piece of legislation that must be introduced in this country. If there is any incentive or any instigation to amend the Lands and Deeds Registry Act, and I must argue that we need to do land reform in this country. We're the only country that takes too long to undertake land reforms. The only thing we always do is we pick up small pieces of legislation and introduce them in the law. We must take a wholesale proposal to amend our land laws so that each amendment will be speaking to the other within the regime of land administration in the country. But to pick out this one provision, as controversial as it sounds, would actually be to regress rather than to progress. We have a scenario that helps us to resolve these land disputes currently. I think if there's going to be a solution, it is to expand capacity within the Lands Tribunal, expand capacity within the High Court of Judicature itself. The High Court is even working towards this progressive expansion of jurisdiction. If you've seen in the High Court now, financial crimes have got their own division. Okay, domestic family crimes have got their own division. We possibly should be talking about including what is called the land division that deals with land disputes. That way we will expand capacity of resolving these issues, and the answers to some of the problems that are arising in the registrar's office will be expedited in terms of being provided for in the High Court Act itself, rather than providing power that is judicial, that is judicial in its nature to an administrative institution. That's my concluding remark, Mr. Chair. Thank you very much for the opportunity.
Thank you. I'm grateful for your great submission. At the beginning of our interaction, we had actually conferred with immunity. We've now decided to withdraw that immunity so that whatever you've said here remains here. If you decide to go and say it outside, you have your own immunity. Thank you very much for coming, and please have a great day.
Thank you very much, Chair, and honorable members. I'm so grateful. May God's blessings in the deliberations for the next witnesses. Thank you.